Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. And tonight's lecture is going to be on Chapter 7, where we will be talking about homicide. And more specifically, we'll look a little bit deeper into, what is criminal homicide, and then we'll look at the differences between murder and manslaughter, negligent suicide, negligent homicide, and then we'll finish up with suicide. So with that being said, let's go ahead and jump right into our lecture tonight. And I want to start off by introducing you to the FBI crime clock. Now, the FBI is the clearinghouse for Part 1 crime statistics for the United States, and therefore every state in the U.S. is required to submit their Part 1 crime statistics to the FBI Uniform Crime Report, if you will. It's called the UCR, and annually the FBI will publish crime statistics and crime trends. So if you're interested in statistics in your particular city, you could look on the FBI's website and it will break all those Part 1 crimes down by city as well. Another thing that they do is they will put together an annual crime clock that shows basically Part 1 crimes across the United States in their frequency, meaning how often do they actually occur, not just in a city, but across the U.S. And it's interesting to note how many crimes there actually are. So here is one from 2016, and it shows at the top, you can see it shows that a violent crime occurred every 25.3 seconds, and it has a list of different types of crimes beneath it. And then it also shows a property crime occurred every 4 seconds, and it shows a list of those crimes that are being tracked as well. And for us, the interest is on homicide, which incorporates murder, which will show that there is a murder across the United States approximately every 30.6 seconds. So while that is extremely frightening, it will tell you the frequency of these types of crimes. Now, along with that, I have incorporated a criminal homicide chart, if you will, for California, kind of an overview, because a lot of times we mistakenly interpret homicide and murder. We think they're the same thing, and realistically they are not. And what is manslaughter, and what is vehicular manslaughter, and are there lawful deaths and unlawful deaths, and blah blah blah. So this chart will help you get a better overview. And while things are a little bit different from state to state, a lot of things are similar. So I thought this would be a great way to kind of show you an overview on how this works. So quickly, homicide is more of the umbrella. Okay, it's not a crime in itself, it's descriptive of a lot of different acts. One of them being murder, which is here. It falls under the umbrella of homicide. And here, death, that falls under the umbrella of homicide. And there is lawful and unlawful. And we'll get into that more as we go through the chapter, but this will help you separate these categories and underneath give you an example of what a lawful death could be, what an excusable death could be, and what an unlawful death in a couple of different circumstances could be. So we'll get more into that, but let's jump into our lecture. So a tragic set of events occurred on August 19th, 2014 that will illustrate a very interesting criminal law doctrine. So in the evening on that date in Orlando, Florida, an Orlando police officer responded to 911 reports that a man was brandishing a gun and behaving belligerently in a local bar in downtown Orlando. Now, when the officers arrived, they discovered a gentleman by the name of Cody Roach, a 23-year-old male, pounding on the bar's door. And moments before they arrived, Roach had been pushed out of the bar and the door to the bar had been locked. So basically, he was thrown out of the bar. Now, Roach is alleged to have ignored several commands by police to get on the ground, and one of the officers there unsuccessfully attempted to tase him. Now, the officers reported that Roach then reached for his waistband where he had a gun, and in response, one of the officers fired 9 rounds at Roach. Several hit Roach, another struck a fellow police officer, and one struck a young lady by the name of Maria Godinez, a 22-year-old customer. And Godinez, unfortunately, later died from her wound. Now, Roach and the officers survive, and as it turns out, the gun, which happened to be stolen, was unloaded. Now, originally, the state attorney's office charged Roach with the murder of Godinez. The charge was later reduced to second-degree murder, in addition to some lesser charges. But how can Roach be punished for the killing of the bar patron when he didn't fire the weapon that ended her life? Meaning, can he be responsible for that? So, common law has long recognized an exception to the actus reus requirement in cases when the felonious actions of a suspect led to the death, even if unintended, and committed by a third party. And the doctrine known as felony murder, or the felony murder rule, stands on the ground that felons are so culpable, so wrong in their behavior, that they assume the risk and responsibility for resulting loss of life. And we'll talk more about that later on as we get into this lecture. But what is criminal homicide? And really quick as well, this is one of those chapters that I would really suggest highly that you read and understand the definitions. Those key terms that are listed in your textbook, because there's going to be a lot of those terms that we're going to go over. So, some deaths are accidental. Others are caused by human intent, recklessness, or even negligence. And an accidental death, or one that is caused by unexpected or unintended means, can be distinguished from an accidental killing, which is the result of a purposeful human act lawfully undertaken in the responsible belief that no harm will result. And again, I know it's confusing, but if you go back to that chart, you can see we talk about death. Well, there is an excusable area. There's a lawful area for killing or death, and there's an unlawful area. Okay, so we'll get to those, but understand again that we can distinguish, okay, an accidental death, or one that is caused by an unexpected or unintended means, from an accidental killing, which is the result of perhaps a purposeful human act lawfully undertaken in the responsible belief that perhaps no harm would result. So let's talk about homicide. Homicide is the killing of one human being by another human being. And by definition, suicide isn't included here. More precisely, or more specifically, homicide could be defined as the killing of one human being by the act, procurement, or omission of another human being. And there are basically 3 types of homicide that we're going to talk about, and that'll be justifiable, excusable, and criminal. And I want you to note that criminal homicide refers to those in which criminal liability can, in fact, attach. So what is justifiable? Well, justifiable homicide are those permitted under law, as in the case of a state-ordered execution, the military killing of an enemy soldier in the line of duty, or law enforcement acting in the line of duty. And sometimes self-defense can be classified as justifiable, although it may also be considered excusable. So if you look at the photograph right here, we kind of think about the different, types of killing or homicide that I had on that chart. This perhaps could fall under the justifiable realm, where a law enforcement officer is in immediate danger of being stabbed to death by this suspect who is in possession of a deadly weapon, that being the knife that you can see in the person's right hand. And you can also look at the close proximity between the officer and the suspect, which is also part of that imminent danger thing that we'll talk about a little bit later. So with that, what is excusable? Well, excusable homicides are those homicides that may involve some fault, but are not enough for the act to be considered criminal. And they're conducted in a manner that the criminal law does not prohibit. Also, a killing that may involve some fault, but is not criminal homicide. So a death caused by a vehicular accident in which the driver was not negligent may be or could fall under that excusable section. And then finally, criminal homicide. Well, the term criminal homicide refers to only those homicides to which criminal liability may attach. Now, generally speaking, any homicide that is not classified as justifiable or excusable may be considered criminal homicide. And remember, there's lots of different definitions and a couple of different ones for different states as well. Okay, so just kind of keep all of that in mind. So the early common law only recognized murder, and all murders were punished with death. And over time, however, the distinction between murder and manslaughter and the latter's lesser punishment of life imprisonment developed, as did the justifications and excuse defenses. So let's look at a couple of different definitions before we move on a little bit further. So criminal homicide is the purposeful, knowing, reckless, or negligent killing of one human being by another. Now, murder, on the other hand, is the unlawful killing of a human being carried out with malice, okay, or planned in advance. Malice aforethought is what they call it, and we'll get into this a little bit deeper. And manslaughter is the unlawful killing of a human being without malice, where premeditation is lacking. So again, a lot of definitions and a lot of different things that we're going to be covering. So eventually, both murder and manslaughter were subdivided into graded offenses. And some distinctions were made between voluntary and involuntary manslaughter, and between first degree and second degree murder. And each of these different levels or grades will be discussed a little bit later. And most states today have followed the model penal code and have passed laws recognizing different types of criminal homicides. So we need to kind of keep that in mind. Again, the distinction between murder and manslaughter has really evolved, including, as did justifications and excuses and defenses and things like that. So, as I said, most states follow the model penal code and recognize three types of criminal homicide. And the first is murder, of which there are, or there may be, various degrees. Manslaughter, of which there may be various kinds. And negligent homicide, which some consider to be a variety of involuntary manslaughter. And again, we'll get into these definitions a little bit more, but before we go there, when we're talking about criminal homicide, we need to focus our efforts a little bit on corpus delicti. And we've had a chapter on that, but let's look at the corpus delicti of a criminal homicide. And it consists of two different things. So it consists of the death of a human being and the fact that the death was caused by the criminal act or agency of another person. And, you know, we could go back to chapter 3 where we really had a detailed discussion about the concept of corpus delicti. But included within this definition is the requirement that the victim's death was the natural and probable consequence of another person's unlawful conduct. So, under common law, an individual could not be convicted of any grade of criminal homicide unless the body of the deceased, or at least portions of that, were found and sufficiently identified to establish the fact of the victim's death. Now this requirement has since been modified in most cases today, or in most states today. Today, to conduct a successful prosecution on the charge of criminal homicide, the state must establish the corpus delicti of the crime of homicide. That is, the prosecution must establish the cause of death and show that the death was caused by, the criminal act of the accused. Now, if you recall, or if you may recall from the earlier discussion of corpus delicti, a confession alone is not enough, nor is a confession and a missing person. And if you watch that video titled No Corpus Delicti in the prior chapter, back in chapter 3, you'll have a little bit more context on what I'm talking about. In most jurisdictions, some form of corroborating evidence has to be there. So hopefully that makes sense as it relates to the corpus delicti thing. And although discovery of a body of a murder victim may not be necessary to prove criminal homicide in courts today, a conviction requires prosecutors to prove that the death in question was caused, again, by the act, agency, procurement, or omission of the accused. Now, in a case, Williams versus State, for example, the defendant was convicted after he confessed to shooting the victim at close range with a shotgun, although the victim's body was never recovered. And in addition, several witnesses testified that the victim was dead and that they helped the defendant dispose of the body. Now, a Texas appellate court, which upheld Williams' conviction, ruled that the state had successfully established that the victim was dead, even though no body had been found, and that the state had established that the victim's death was caused by the criminal act of the accused, thus meeting the requirements for proving criminal homicide under state law. So kind of an interesting thing. So the question I would ask now is, do you really need a body to show or to get a conviction. And in some states you might. In California, you don't. You don't have to have a body. And obviously, in this particular case here in Texas, you don't need an actual body as well. So with that, let's move on to basically defining death, if you will. Now, there is an alive requirement that is needed to be established, or that's been modified in some states. So let's look at it now. So the alive requirement has been modified in some states where the killing of a fetus is now considered homicide. And this has always been one of those very contentious type things that kind of been out there. Is a fetus determined, is it alive? Is it not alive? And how do we deal with that? Well, in Penal Code 187, California law defines murder as the unlawful killing of a human being or fetus with malice aforethought. And there's a case, the Mary Chavez case, that gives us a little bit more insight on that particular one. And we're not going to go through the whole thing, but I just want you to know that while this has been this is a hot topic and a point of debate, some sections where some states have kind of modified that to where a fetus is considered homicide, and some states like California actually puts it in the code. So now we know, without any question, exactly what homicide or what murder defines. So let's kind of go back here. By 1996, following California, 13 states had amended the wording of their homicide statutes to include a viable fetus under the notion of a living human being. And viable is said to mean that if the fetus had been born prematurely at the time it was killed, it would have had at least a 75% chance of survival for at least a period of time outside of the womb. And so again, that just, it kind of gives you a little bit more information on the debate between, life or death. And we're not going to sit here and debate the moral principles or what have you, but it does kind of at least walk you through those issues relating to a fetus. So let's move on with criminal homicide. Now, the model penal code provides no definition of death. So as we try to define it today, more than 30 states by statute or court decision have adopted an approach in using what they call the cessation of brain function in defining death. And there is still widespread disagreement over what constitutes death. So a central issue in criminal homicide cases is the definition of death, which is certainly needed before criminal prosecution can begin in order to establish that death has actually occurred. Now, again, the MPC provides no definition of death. The code's commentary cites two reasons for this particular failure. One, contemporary scientific understanding of death were not available when the code was first drafted, making death difficult to define at that particular time. And two, the delicate contemporary interplay between criminal law and advances in medical science is still too nebulous to reduce to a statutory formula. So again, the common law rule was that death or cessation of life occurs when a person's heartbeat and respirations cease. And in 1968, a report defining the characteristics of a permanently non-functioning brain was published by a committee of the Harvard Medical School, and that became the basis for the concept of death. So brain death is death determined by a flat reading on an EEG, usually after a 24-hour period or by another or other medical criteria. Now, another interesting concept we're going to look at quickly is going to be time of death. Because sometimes victims of homicides suffer injuries, but they don't die immediately. And in some cases, death may occur hours, days, or even months after causing or after the causing act was committed. And I put in a clip from a newspaper. Shooting victim dies 2 years later for charged in killing. So we know that, sometimes victims of homicidal acts, they suffer injuries, but they don't die immediately. So at common law, there was the year and a day rule that was based on the belief that causation and proof of causation became ever more difficult with the passage of time. Meaning, like, was it a medical issue, or was it the act that the person actually got shot? Was it the gunshot wound that killed him, or was it some medical thing that happened later on? And the more time that passed, the more difficult those were to prove. Now, most U.S. jurisdictions have abolished that year and a day rule. California is unique, and some other states have gone along with it. If the victim does not die within 3 years and 1 day after the date when the cause of death allegedly occurred, California state law includes a presumption that the homicide was not a criminal act of murder or manslaughter, and therefore the prosecutor must rebut the presumption in order to pursue a second-degree murder charge. So California gives you the 3 years and a day rule. So again, kind of interesting. So for example, think about this. In 1981, John Hinckley attempted to assassinate President Ronald Reagan. Now, Hinckley fired 6 rounds from a handgun at Reagan, striking the president's press secretary, James Brady, a Secret Service agent, and a Washington, D.C. police officer. Now, 1 bullet ricocheted off the president's armored limousine and into the president. James Brady was struck on the head and left permanently disabled. Now, in August of 2014, 33 years later after the shooting, Brady died. And the coroner determined the cause of death to be the bullet fired by Hinckley so many years earlier, and federal prosecutors considered charging Hinckley with Brady's murder. Now, but there were several legal hurdles that had to be dealt with. But that was just kind of, think about that. Hinckley had been charged with several crimes after the incident, and a jury found him not guilty by reason of insanity. So, again, just a very interesting case law to look at. But California, in essence, has the 3 year and a day rule. So, just kind of a note. Now we're gonna talk about something called proximate cause, and I'm gonna spend a little bit of time here, hopefully not too much. And bear with me as I go through this, because again, there's so many different definitions here. Okay, so here we go. We're going to get into this. Criminal homicide must be the result of an affirmative act. an omission to act, or criminal negligence. So for criminal liability to accrue, the cause of death must not be so remote as to fail to constitute natural and probable consequences of the defendant's act. Now, I know that's a lot of legalese. So, in other words, for charges of homicide to be brought successfully, a person's death must be the proximate result of the human act. Okay, so does that kind of make sense? And hopefully it does. Now, proximate cause, we discussed pretty much in great deal back in chapter 3, but suffice it to say here that in homicide cases, a determination of proximate cause requires that death be a natural and probable consequence of the act in question. So again, when we're talking about proximate cause in homicide, for criminal liability to accrue in a criminal homicide, the cause of death must not be so remote as to fail to constitute the natural and probable consequences of the defendant's act. Death must actually be a natural and probable consequence of the act in question. And a test that is frequently used can be stated this way. If the original act had not occurred, would the victim have died? Now that seems kind of simplistic, but if you may recall from earlier chapters that this test is kind of referred to, remember that but-for test? So if, for example, a victim is shot by the accused, resulting in a non-fatal wound, but the victim later dies during an operation to remove the bullet, the shooting constitutes, or does the shooting constitute that proximate cause? And the answer actually could be yes. Were concurring causes, or where concurring causes contribute to a victim's death, an accused may be held criminally liable by reason of conduct that directly contributes to the fatal assault. So example, removing a victim from life support, that doesn't relieve the suspect of any criminal responsibility. But think about that again, okay, that but-for test. So, similarly, let's talk about another case, People versus Moan, M-O-A-N. A victim who already very ill suffered an injury that accelerated his death. Nonetheless, the injury was considered the proximate cause of death. Hence, an act that is determined to be the proximate cause of death need not be the only or sole cause of a person's death. And the Supreme Court also discusses that but-for test in one of those capstone cases in your book, which I would suggest that you read in that case of Barrage versus United States. So a couple of interesting examples here. And a couple other points. An accused cannot be found guilty of criminal homicide when death is brought about by grossly erroneous medical or surgical treatment rather than by the wound inflicted by the accused. So now let's look under the umbrella, at least in California. Remember, the umbrella is homicide, and under that are these other aspects, if you will, and murder is one of those. So, and we're going to talk about it now. So, murder is the first of three types of criminal homicide. And the elements of murder are the unlawful killing of a human being with malice aforethought. And remember, we talked about what malice aforethought was, and we talked about what premeditation was. And if you remember, premeditation is what? Well, it's the act of deliberating or meditating on, or planning a course of action, such as a crime. In most states, murder is divided into two categories. It's either going to be first degree or it's going to be second degree. Now, first degree murder is any willful, deliberate, and premeditated unlawful killing. And again, premeditation means the act of deliberating, like thinking, meditating on, or planning a course of action such as a crime. And it's also an opportunity for reflection between the time the intent to act is formed and the act itself is committed. And first degree murder is clearly first degree when it is committed by certain acts like poisoning, or by lying in wait, or when it involves torture. And in California, if we go back to that chart, there's, I think, a laundry list of different crimes that are classified as murder in the first degree. And first degree murder is usually punishable by death or life in prison. So in states with 2 degrees of murder recognized, all murders other than first degree are said to be second degree. And an essential element of the crime of murder, again, is malice. And we talked about that, and this is really important, okay? Under common law, the grand criterion that distinguished murder from other killing was malice on the part of the killer. And malice was not necessarily malevolent to the deceased particularly, but any evil design in general. The wicked, depraved, or malignant heart. As a contemporary legal term, malice refers to the intentional commission of a wrongful act without just cause or legal excuse. And malice encompasses both intentional carrying out of a hurtful act without cause and the hostility of one individual towards another. In cases of homicide, the term means an intention to kill. So malice is a legal term that refers to the intentional doing of a wrongful act without legal excuse. Now, remember I talked about the California codes, and we talked about first degree and second degree. Well, just as a quick reminder, California kind of makes it easy, and other states might have something similar. But if you look here, California gives you the crimes that are considered to be first degree. Remember, you heard me talk about poison or torture or lying in wait. Well, there are other crimes that are listed here for California. So just to kind of give you a little bit of information on the California side. So continuing on with this malice aforethought. Okay, first degree murder is often described as requiring this word, this malice aforethought. And this is a historical term that connotes a malicious design to kill or injure. Hence, malice aforethought and premeditation were synonyms. The term malice aforethought, however, has undergone quite a few changes, if you will, or evolution. The definition is an unjustifiable, inexcusable, and unmitigated person endangering state of mind. But remember, since we talked about common law, this term malice aforethought has undergone a considerable evolution, and today it includes several states of mind. It may, for example, encompass the causing of death during the commission of specified felonies, like the list I showed you, whether or not the offender premeditated the killing. And as explained in the now classic 1968 decision of Green versus U.S., malice aforethought is an unjustifiable, inexcusable, and unmitigated person-endangering state of mind. In contemporary murder statutes, the term malice aforethought is generally understood to mean a killing while in possession of one of the following 5 mental states, and we'll talk a little bit about that as well. But well, let me go ahead and do that. 1, intent to kill. 2, an intent to inflict great bodily injury. 3, an intent to commit a felony, as in the felony murder rule. 4, an intent to resist a lawful arrest. Or 5, an awareness that one is engaged in conduct that carries with it a high risk of someone's death. So those are kind of, those are some contemporary malice aforethought statutes that are listed in the murder statute. So again, malice aforethought, a historical term that connotes a malicious design to kill or injure. In modern context, the term can be understood as the intention to kill, actual or implied, okay, under circumstances which do not constitute excuse or justification or mitigate the offense to manslaughter. And the intent to kill is actual or express. Implied, when the defendant intends to cause great bodily harm, or where the natural tendency of the defendant's behavior is to cause death or great bodily harm. Now, malice may exist where the killing is unpremeditated, and malice may be inferred from several different circumstances. And in some circumstances, a defendant may be guilty of murder if he or she acts in a manner that creates an unusually high risk of another's death, and that does in fact result in death. Most states require a subjective realization of risk on the theory that anything less is too removed from the notion of an intent to kill to justify a charge of murder. And that brings us to the point of capital murder. Now, in some states, murder for which the death penalty is authorized are treated as a separate class of murder called capital murder. And these killings have to have been premeditated and deliberate. So capital murder, by definition, murder for which the death penalty is authorized by law. Now, continuing on, the idea is that those who kill with clear intention should be subject to capital punishment. So what makes that different then from premeditated murder? Well, let's look at what premeditated murder is. This is murder in which the intent to kill is formed pursuant to the pre-existing reflection rather than as the result of a sudden impulse or heat of passion. So therefore, the defendant must have considered the act before the killing. So hopefully that makes sense. And aggravated murder is another definition. This is murder plus one or more aggravating factors as specified by law. So let me give you a little bit more on that. Following the lead of the Model Penal Code, some states have rejected premeditation and deliberation as a basis for identifying murder as one that deserves the death penalties. Now, those states have legislatively defined capital murder as murder plus one or more specific aggravating factors constituting what is sometimes called aggravated murder. And the term aggravated murder is found in the statutes of some states like Utah, Washington, and Ohio. Although other states depict capital murder as first-degree murder with aggravating factors with special circumstances. So aggravated murder is murder plus one or more of these aggravating factors as specified by law. So now we're going to quickly talk about the felony murder rule. And this is a very interesting case because it can hold responsibility for a defendant based on that case that I talked to you about where somebody was shot by the officer. I'm sorry, yeah, by the officer, but the suspect was the one that actually had the gun, and that's the case I explained at the very beginning. Excuse me. So the felony murder rule, this is a rule that establishes murder liability for a defendant if another person dies during the commission of certain felonies. And it's intended to deter negligent and accidental killings during the commission of a felony. Now, most jurisdictions use an inherently dangerous test to decide when the felony murder rule applies. So let me say that again. Most jurisdictions use what they call an inherently dangerous test to decide when that felony murder actually applies. And if we were to look at it a little bit more, under common law, all felonies were subject to the felony murder rule. Now, over the past 100 years, however, that rule has become more limited in scope in most jurisdictions. And again, every state has numerous statutory felonies that were unknown at common law, and most pose virtually no unusual a threat. Accordingly, the felony murder rule is today applied only to certain felonies. Generally, these are 3 schemes inherently dangerous to life. So, or inherently, these again are 3 schemes for identifying those felonies which the rule applies, and that includes those acts that are inherently dangerous to life or health. Number 2 are held to be malum in se, or number 3 were felonies under common law. And malum in se acts for the purpose of the murder rule includes all felonies, all breaches of public order, injuries to persons or property, outrage upon public decency or goods or morals, and breaches of official duty when done willfully or corruptly. So I say all that to say that most jurisdictions now use what they call that inherently dangerous test to decide when the felony murder rule applies. And felonies are inherently dangerous when by their nature or by the nature of their commission, they may result in death or serious bodily harm. Also, the rules of proximate cause discussed earlier generally apply in felony murder situations, as the felony murder rule requires a causal relationship between the felony and the death. It's not sufficient that a death merely occurs at the same time as a felony. In some way, the felony must give rise to the killings. So on page 227 in your book, it talks a little bit about the felony murder rule, and it gives you a little diagram on how that rule actually applies. So because we're limited on time, we're going to move on to manslaughter. Manslaughter is the second of 3 general types of criminal homicide discussed in this lecture, and manslaughter is the unlawful killing of a human being without malice. And and manslaughter differs from murder in that malice and premeditation are lacking. Hence the elements of the crime of manslaughter are an unlawful killing of a human being without malice. And with that, we know that there are a couple of different types of manslaughter. There's going to be voluntary and involuntary. So let's look at voluntary manslaughter. Manslaughter occurs without deliberation, planning, or premeditation, and may be voluntary or involuntary. So remember, we're going to look at both pieces. Now, voluntary manslaughter is the unlawful killing of a human being without malice, which is done intentionally upon sudden quarrel or in the heat of passion. In other words, voluntary manslaughter is a homicide associated with sudden fit of rage or passion. Such a killing, although intentional, is neither premeditated nor motivated by basic evil intent. Voluntary manslaughter would otherwise be murder, except that it is committed in response to what we call adequate provocation, as when a person, say, finds his or her spouse in bed with another. The provocation is said to be adequate if it would cause a reasonable person to lose self-control. So adequate provocation is also termed reasonable provocation. So hopefully that kind of makes a little bit of sense. And if you go back to that chart that I had for California that shows the different things under the umbrella of homicide, you'll see exactly that. So again, voluntary manslaughter can be more formally defined as a killing committed, without lawful justification. Yes, without lawful justification. Okay, so the next one, involuntary. So we talked about voluntary, so now let's go to the involuntary. Involuntary manslaughter is an unlawful homicide that is unintentionally caused, and that is either the result of an unlawful act other than a dangerous felony, or occurs as the result of criminal negligence or recklessness. So again, an unlawful involuntary manslaughter is an unlawful homicide that is unintentionally caused, and that is either the result of an unlawful act other than a dangerous felony, or a lawful act done in an unlawful way, or it occurs as the result of criminal negligence or recklessness. Now, the central distinguishing feature between voluntary and involuntary manslaughter is the absence in involuntary manslaughter of the intention to kill or to commit an unlawful act that might reasonably produce death or great bodily harm. In other words, in cases of voluntary manslaughter, killing is intentional, whereas it is unintentional in instances or cases of involuntary manslaughter. So hopefully that kind of spells that out, the distinguishing factors. And we've kind of already went through this here. Well, what about the last one, the last piece? Criminal negligence. Well, what is that? Well, unintentional killings may constitute involuntary manslaughter when they result from criminal negligence, which in itself may be unlawful, or from something that we call gross negligence. Some state laws describe a special category of involuntary manslaughter called criminally negligent homicide. And although the definition may sound a bit circular, criminally negligent homicide is usually defined as a homicide resulting from criminal negligence. So by definition, homicide that results from criminal negligence. So again, kind of an interesting thing. So criminal negligence is negligence of such a nature and to such a degree that it is punishable as a crime. A flagrant and reckless disregard of the safety of others, or willful indifference to the safety of others. The offense of negligent homicide allows for the prosecution where the defendant's conduct was negligent, but the degree of negligence involved did not amount to gross or criminal negligence or recklessness. So the killing of a person without the intent to kill, when the killing takes place while the offender is performing a negligent act, or when the offender fails to exercise reasonable or prudent care. Now, under the Model Penal Code and the codes of many states, negligent homicide is a third-degree felony, and it is considered less serious than manslaughter. Now, it's not that way in California, but again, sometimes, again, states have different codes. And then finally, what about this thing called vehicular homicide? Well, this is the killing of a human being as a result of another person's operation of a motor vehicle in a reckless manner likely to cause death or great bodily harm. And then finally, suicide. Under common law, suicide was murder, and anyone who assisted another in committing suicide was a party to a murder. Now, many states now have the statutory crime of aiding or assisting suicide, and mercy killings in which a person is actively seek to end the life of someone who is suffering are frequently prosecuted as homicides. So that's going to be the end of the lecture. But what I wanted to do really quick was go back to the very beginning and just briefly, while we have a couple of minutes left, remind you of this chart that I have. So while we covered a bunch of terms, okay, we talked about these manslaughter cases towards the end. And look, you can look at it here, voluntary manslaughter. Now, while it's California, it's still consistent. Without malice, sudden quarrel. It's an intentional killing, okay? And then you can look here, involuntary manslaughter. Without malice, an unlawful act causing death or an unintentional killing. Now, again, this is California, so it could be a little bit different, but this at least gives you the umbrella of homicide and how things fall underneath homicide. So I hope that this chart helps you in kind of understanding a lot of the different aspects of criminal homicide. So with that being said, don't forget at the end of the chapter to look at the summary that hits the highlights of the chapter, and very much so and very important in this chapter, please take the time to look at the definitions, because there are so many definitions that you are going to need to know. So with that being said, that will conclude the Chapter 7 lecture on homicide, and until next time.